first in the House and then online to introduce themselves. Thank you.
Good morning, ladies and gentlemen. Andrikus van der Westhuizen, member of the committee.
Good morning, Chair.
Thank you, Member Select.
Isaac Mbulelo Sileku. Good morning to everyone.
Member VB. Let's see, Member VB online. Okay, Member VB is online. We'll come back to him. I'm going to ask the HOD to introduce her team.
Good morning, Chair, members. Jackie Gooch, Head of Department of Transport and Public Works. And if you don't mind, I'll actually just ask the team to run down the benches to introduce themselves. Thanks, Tony.
Thank you. Yes, good morning. I'm Tony Abramson. I'm from Transjuris. We're consultants assisting the department with this legislation.
Good morning. I'm Amanda Tor from the Department of the Premier Legal Services, State Law Advisor. Thank you.
Morning, Chair, honourable members and colleagues. Carl October, Chief Director, Roads Planning, Department of Transport and Public Works.
Good morning. I'm Scott Carstens, Chief Engineer, Road Use Management at the Roads Branch of the Department of Transport and Public Works.
Morning, Chairperson. My name is Romeo. My surname is Maastorp. I'm a legal advisor to WCPP. Thank you.
Thank you, colleagues. Member Wimby, you want to introduce yourself? Member Wimby, yeah, so you unmute yourself. Okay.
Can you hear me, Chairperson?
Yes, I can hear you now, sir.
My apologies, sincere apologies. Good morning, Chairperson and members of the committee, as well as the delegation that has visited us. My name is Lulama Mvimbi. I'm the member of the committee.
Thank you very much. Mr. Fenner online.
Steve Fenner, assistant to Tony Abramson of Transjuris.
Thank you very much. Is there anybody else online that wants to introduce themselves? No one online. Thank you very much. Colleagues, we're meeting to discuss the Western Cape Transport Infrastructure Bill this morning. By now, all of us are aware of the rules of engagement when it comes to online meetings, so please make sure that you are muted, that you don't switch your camera on unnecessarily. If you want to keep it on, you're welcome to do so, but then you need to be present when your camera is on and not be making coffee, and things like that. So we're discussing one item on the agenda today, which is the Western Cape Transport and Infrastructure Bill. You want to look at translations, man? Yes. We do have translations. If you want to speak in any one of the 3 languages, you're welcome to do so. Just a bit of background, this bill was first introduced in 13 April 2021 during the hard lockdown. It was advertised in the Provincial Gazette on the 12th of July. We started the process on the 4th of August 2021. Obviously, COVID and the hard lockdown had an impact on getting this bill through. This bill was advertised in all the newspapers in the Western Cape, the Burgers, Cape Argus, City Vision, George Herald. And also, we also had public hearings on this bill in George and also in this chambers. We received several oral and written submissions. It was provided to the department for us in a matrix. That matrix was distributed. We had several briefings. The last one was on the 16th of August. We deliberated, discussed. We had another meeting in November. There was a technical meeting also held with officials and member of the West Stations, 1 or 2 other persons who had discussions around some of the technicalities of the bill. And then last comments we received from the department was in November from the head of department, sharing clarifications around concerns that were made by members of the committee. We've subsequently had another meeting, the last one this morning, 7 o'clock, 6:30 actually, myself, Member van der Westhuizen, and one or two other members. We've managed to cut down to 4 the clarifications sought and matters that Member van der Wester strongly feels that should be in the bill from his initial. So we're going somewhere from where we started more than 18 months ago, and those 4 clauses has been presented in the bill. In fact, what I'm going to do, as opposed to going clause by clause, I would rather we go to those 4 specific comments and deal with Member van der Wester. You're comfortable with that? Gaan ons reguit na die vet toe. We deal with those particular matters Member raised. The officials have not had sight of this. Like I said, we've literally had this meeting from 6:30 this morning to finalize these 4 matters. So I know this is the first time that you are going to see it, and you're welcome to accountable. You say you need to spend half an hour going through it. I'll fully respect that, but she did not have sight to it. So, and perhaps can I ask Member van der Westhuizen to explain his reasons and just take us through those specific points, then also helps you understand where he's coming from. And then we can take it from there. Perhaps Lou do this. The Member van der Westhuizen, I hand over to you.
Yes, thank you, Chair, and good morning, everybody. As you know, I'm also the chairperson of the Standing Committee on Agriculture, and therefore I'm extremely concerned and involved with the aspects of this bill that may impact on agricultural practices. The first proposed amendment is that, and you will find it under 17.2, which is on page 20 of the bill in its printed form. 72.
Can we just quickly, Member van der Westhuizen, can we, Johan, just for the sake of clarity, just use the document that you distributed, and so we operate from the same document. Member van der Westhuizen, can we use the clauses as amend this document?
Chairperson, the clauses that's on that document and the bill is exactly the same. Yeah.
So, okay, so because I want to make sure we all work from the same document, just for the avoidance of doubt.
This one.
Yeah.
You want us to work from
It's
this
better
one?
on my.
Okay.
Okay.
And Chairperson, just for clarity, we're working on the bill and not the Gazette version.
Yeah.
The bill version, meaning that the lines might not correspond exactly the same as it is in the Gazette, because it's slightly different print. But it's the same bill. It's just the lines might be.
So does everybody have a copy of that bill?
The bill.
Or as advertised in the
Yeah.
Gazette.
Yeah.
The 3 languages.
Yeah.
Okay.
Sorry, was hang on, Member van der Westhuizen?
I've got a copy, Chair, so I'll just check with Amanda if it's the updated copy.
And you seem to have a, just want to get clarity, yes?
Yeah, I'm just a little bit unclear, Mr. Coetzee. As I understand it, there would be only one version before the committee at that stage, the one advertised in the Provincial Gazette, which has got line numbers.
Yes, there is only one version of the bill. The one that's printed in the Gazette are normally printed slightly different to the actual bill that's printed.
Okay.
And then the line numbers might not always correspond,
Okay.
but it is only the same bill, yeah.
I will not be referring to line numbers. I will be referring to paragraph numbers then, or clause numbers. Is that more correct? 17.2, perhaps just as a background, I may say that unfortunately we are going to repeal the Act 21 of 1940. Now, Act 21 of 1940 provides, for example, and Mr. Carstens pointed it out previously, for bona fide agricultural structures within the building restriction line. And I would propose that that clause of Act 21 of 1940 be retained, although the Act is repealed, and therefore we carry this, and this is an insertion then, after line to add, provided that the preceding provisions of this section shall not apply in connection with an irrigation work, a farm dwelling house, or any other structure on a farm intended to be used in connection with bona fide farming operations. That is taken verbatim from the 1940 piece of legislation. Good. So that is the first amendment. Would you like us to stop, or shall I continue?
You can stop there. Just get any input on that particular clause?
Chair, I think got a needed opportunity to consult with the officials. Just to say, my first impression, it would not be in the right place in any event. I don't think it would be located in the right place of the bill. But just to say, we would need to interrogate the rationale for why it's proposed to now be included, bearing in mind the change in the constitutional scheme since 1996. Thank you.
Member van der Westhuizen, just give more clarity on it.
No, can I say that the problem that I have is that quite often farming operations require of people to, have a borehole at a specific place within this building restriction area, which is at times quite big, 500 meters at an intersection of roads, will sterilize quite an enormous piece of land for agricultural purposes. And quite often, farmers tend to put up their water tanks, etc., on the highest point of their land, so they can use gravity to, for example, feed water into the troughs and so on for animals from their farm. And that highest point is obviously, but is often right next to the road itself, or then at least the road reserve. And that includes windmills, water pumps. Nowadays, unfortunately, quite often they need to put down even generators, etc., because you want the generator to be close to your water source and things like that. So, and as I've said, this has been in the legislation in the past. Mr. Carstens referred to that. Unfortunately, it is not being referred to in the bill before us, or even in the regulations, as far as I could see, and therefore I would like to this to be included in this bill. Thank you.
Thank you. Can I just make some comments? I understand exactly what you're saying. That what you're concerned about is within a 500-meter radius of the intersection of two major roads, or a road and a railway line. The bill prohibits any development over there. And the reason for that is because that 500-meter radius is making provision for a possible future interchange between these two major roads, which requires an enormous amount of space. It doesn't mean that the farmer who wishes to put up this installation can't do so. He would have to apply to the province to do so, and then the province would have to evaluate whether this interchange is going to happen soon or never or whatever, and then could take the necessary decision to allow it. Of course, any existing structures that were in that location when the Act commences would be allowed to stay. I mean, the bill provides for a continuity of structures, and it's just new ones which I think you're worried about. I see in Act 21 where it comes from. I've got a copy. It comes from section 9(1)(e) of Act 21 of 1940, which has that exact wording that you're proposing. But I think if we were to consider it for the bill, it should actually be located in section 47, which is dealing with structures, rather than this section, which is dealing with planning, actually. So, but that's just a matter of where it's located. It's not the matter. It's the principle, I think, is what you're asking for. And if we were to accede to it, it would probably go into 47 somewhere rather than into 18.
So the 2 points that I picked up, Member van der Westhuizen, is the existing structures wouldn't be effective. I think that's also that we dealt with this early this morning, that anything that's existing, because we can't make laws retrospectively, won't be affected. But the new structures, or any going forward, whether it's advertisements, the bills, or the billboards, etc., will need to be applied for. Is that, I think we all, are you uncomfortable with that? Is that what you're saying?
I'm uncomfortable with the fact that bona fide farming or agriculture structures are being prohibited, and in that people would have to apply for permission as you've stated, to be able to put up such bona fide structures. And we're talking about water tanks. We're talking about little reservoirs, cement dams that people use. We're talking about, in the old days, it used to be windmills. Nowadays, it's quite often a few solar panels with a submersible pump next to it, etc. And I think we need to act on in the interest not only of roads but also of the interest of our farmers that need to produce food, that need to employ people, that we need to support to expand their operations in a country with high unemployment, low economic growth, and a threat to food security. And that is why I believe that. So I've also never heard that the existing Act 1940 caused a huge problem for the infrastructure, road infrastructure, people or department. So I believe that is something that I would like to see to protect the right of farmers to at least, use their land for bona fide farming structures. Thank you.
Chair, thank you. I'd like to perhaps just, if I may, highlight, and perhaps I'm misreading, so my apologies if I am, but perhaps just to go back to what 17.2 indicates. It says outside an urban area, the provincial minister may, so there's first of all the may, in respect of the provincial road, that's a trunk road, main road, etc., 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 and it goes on to say, by notice in the Gazette, declare that the road or railway line has a building restriction area of the 95 metres or the 500 metres. So it first says that the provincial minister may do this. It doesn't say that it's automatic or that it's there. It says that the minister may. It then goes on to say that before making that declaration, the provincial minister must, in the prescribed manner, invite comment from interested and affected parties on the implications of the proposed alteration. So, of course, immediately, if I understand correctly, farmers along that particular route, anybody who's living there, would be deemed an interested and affected party and would be asked for any particular comment before a specific a declaration is made. So I just wanted to flag, and I'm assuming I'm reading the same clause through you, Chair, that Member van Westhuizen is referencing, that it's not reading it that there's an automatic on the promulgation of this act and coming into effect, that it's automatic there are these building line restrictions. It's actually saying that it may be declared after consultation. So I just wanted to make sure that we are still reading the same thing and understanding correctly, that it's not that there's an automatic prohibition from the starting point. And actually, I therefore read it that the building line restriction is as a stock standard, the 5 metres from the boundary. That's the first section of the clause. And then it's saying, well, it may be widened or increased to the 95 in parallel or the 500 radius. And I think that that's on the basis of potentially if there are plans for improvements or upgrades and so on that may be happening, but that then happens in consultation. So I just wanted to flag to make sure that we're all also starting off with the same understanding of what the clause is trying to achieve. Thank you, Chair.
Van der Westhuizen.
So if I understand you correctly, there's a zero building line restriction unless the minister has specifically tried to put in place a building restriction line.
Through you, Chair, my understanding of the reading it is clause 1 says there's a building line on each side of the provincial road or road of joint significance or railway line at a distance of 5 metres from the boundary of the reserve. So my understanding is that the restriction is 5 metres. That's the stock standard, if I read the law correctly. Correct me if I'm wrong.
Yeah, can I just quickly, currently Member van der Westhuizen, if, for example, from Laingsburg, and I think that's to Beaufort West, and you're farmer next to the road and you're farming for the last 70, 80 years, there is a building line there. For the sake of this purpose is 5 metres. Should the minister, there's the R22, go off the N1, should he decide to declare that road a road of joint significance because we've now taken over rail in 2029. Before he does that, he then published an intent to do so. And then every farmer on that road has an opportunity in terms of the following line. Before making a decision, the provincial manner must, in a prescribed manner, invite comment from, so you're not going to ask the people in Wilmansdal, he's going to ask the people on the R22, do you have a problem with X, Y, and Z? Please give us your input.
Thank you very much for that clarification then. I did misread it.
Thank you, that's why we are.
Okay, good.
Thank you.
So then, thank you, Chair.
So then we leave that one out as officially of our list. We go to the next one.
Good. And then the next one is the 32, the one that we've really, I think, spent a bit of time on already. And that is then, sorry, can I just, under 17.2, I think it was included in this list that the words, the commencement of this act, declared before or after the commencement, that should be deleted. I'm not sure if I saw that. Yeah, there it is. Thank you. It is there. Okay. Then 32.3, it's dealing with advertisements. And there my concern has been that, you know, taking into account the definition of an advertisement, that so many of our existing indications of farm names, farm numbers, etc., would now be prohibited. And again, I've almost verbatim, I will indicate the change from the 1940 Act. I propose the following, and let me just see, because I'm now working from my document 32.3, to insert, I've got 32.3b, display outside a public road such that, remember now, it's outside the road. So it's on the fence or whatever. It's not on the road or within the road reserve. Such an advertisement which merely indicates the name or number, and that is what I changed in the past. In the 1940 legislation, it just said the name of a farm. I now also included or number of the farm, or that a particular road or path is a private or farm road or a path and is intended for a particular class of traffic or leads to a particular place, or that a particular act is prohibited or permitted. It's again taken from the 1940 Act. And then C, display on or at a gate such an advertisement which conveys merely the name or number of a property or locality to which the gate gives access, or a warning or a request or direction to close the gate. So I believe that would address a lot of my concerns in terms of farm names, etc., which currently, in terms of my interpretation, would not be allowed under the bill or the regulations. Thank you, Chair. That's my, and then obviously the old B, I believe, must then be renumbered as D. Thank you. Chair, so this is just, you know, the kind of typical close the gate. Trucks more than 8 tons use next entrance, because quite often farmers nowadays pave their ways onto their house. And heavy trucks will damage that. You know more than me about the damage that heavy trucks can cause, and therefore they must use an alternate route to the cellar or wherever the wine is being made, or whatever the case, or the animals may be loaded onto trucks and so on. So that is the again, as I've said, it's verbatim, except that I've added the word of or number of the farm. The word number does not appear in the 1940 Act. Thank you.
Want us to adjourn first for you to have a look at that first? Okay.
Then Chair, the law.
Sorry, just hang on a second.
Sorry, Chair. Honourable, can we just specifically mention that clause again, 32?
32, the third subparagraph, and I propose that there be an insertion of B and C. And so display.
Yeah, I've got. Okay, just concurring with Amanda, sorry, because I've got 32 A and B. I don't see that. Yeah.
So that's correct. We've got A and B, and what Member van der Westhuizen is suggesting, Carl, is based upon what was submitted, their inputs, that there's a new B and C, and that what is currently B becomes D.
Okay, thank you.
Okay.
Continue, Member van der Westhuizen.
Sorry, Mike. When it comes to 32, one of the aspects that I've been raising is my concern that, we're working here with the roads department, and they've got a certain agenda, and their agenda is the one of road safety and transport. That it's only a transport angle from which they are drafting this. But we represent, as I've indicated, also other interests of, in my case, agriculture. We have members in looking at economic development, finance, and so on in this parliament. So also cultural and sports and other interest groups. So the problem that I have is that in drafting the regulations, there's one criterion that is currently included, and that is the criterion of the impact on provincial road traffic and provincial transport operations. And therefore, I would like, but the minister can, it seems to me, decide on the criteria that he or she would like to apply in drafting those regulations. And I thought that a way out would be for us then under 32(5)(b) to say the criteria, so the word "the" gets omitted, criteria, in addition to road safety, and then to also economic impact and heritage considerations, even if it's just those two, to be considered in assessing a display referred to in subsection 1. And that would then be my proposal, so that we just give recognition to the fact that it's not only road safety, not only, let's call it the flow of traffic, etc., but that the minister may make add additional criteria, but at least the economy and heritage would be recognized as valid, can I call it, criteria to be considered. That is my proposed amendment in 32(5)(b).
Thank you.
Maybe, thank you, Chair. Thank you, Honourable van der Westhuizen. Maybe just to get the ball rolling, there was a similar comment in the technical engagements with Honourable van der Westhuizen around the possibility of including economic impacts around advertising. I'm just going from that angle in. So there's two things. One is that road infrastructure by nature does look at economic benefits. For example, we talk about infrastructure-led infrastructure-led investments through transport. So transport intrinsically has a sort of economic socio-spin to it. I think one cannot deny that. So does advertising. Um, so the balance is needed, and the competency around these issues are important. So, as we know, the Constitution provides for transport safety and operations under our department's mandate. However, the mandate for economic benefits and economic impacts is basically a municipal function, and I'm going to ask the team to come in. That's a broad statement, and we need to clarify that. And then to include comments like heritage, on the other hand, which also is holistically handled under the EIA or joint planning provisions within the bill. Maybe that's another point for discussion, is that it is holistically included within the EIA process, which includes things like water use licenses, environmental impact assessments, biodiversity offsets, and the list goes on, including heritage. So I'd like the team to just respond to this. Maybe Amanda, thanks.
Thank you, Chair. I'd just like to refer you to paragraph 2.4 of the response from Ms. Gooch that was sent at the beginning of this year. In particular, the fourth paragraph starting, essentially the point being made is, I do not believe that it's competent for this province to legislate on the balancing of various factors such as heritage, environmental, economic factors pertaining to advertising, which are in essence the core of the municipal functional area of advertising. That's set out in paragraph 2.4. In particular, the advertising bylaws themselves refer to the need to strike a balance. That's echoed in the Samoic document, which is the industry guideline. The balancing of these various factors is sought to be achieved through the detailed mechanisms set out in municipal bylaws, which broadly speaking follow the approach as set out in the industry guideline document, the South African Manual for Outdoor Advertising, published by the National Department of Environmental Affairs and Tourism. This balancing and the mechanisms to achieve it are at the core of the municipal functional area of billboards and the display of advertisements in public places. So that's from paragraph 2.4 of the response. Clearly, the province does have competence in respect of the environment. That's a specific competence, but that would be a totally separate provision in legislation. And that is not, we could not incorporate it as a factor within this bill. The assessment of provincial road and traffic safety considerations, I do not believe it's rational to include those considerations in that assessment. It would be a completely different provision. In different legislation would be my initial inclination, although I haven't specifically looked at that. And similarly with regard to the economy, that's also dealt with in this response. There are a whole range of factors that would make it extremely difficult from a legislative point of view to include it in legislation. How would it be assessed? Would it be possible to assess those factors? So I don't want to repeat the whole response verbatim. It's here, it's been submitted, and the committee would have had a chance to consider it. Thank you, Chair.
From the Westhuizen, then I'll respond.
Yes, thank you. Can I just say, the bill says the provincial minister may make regulations prescribing the criteria. So we're already saying to the minister, you may make regulations prescribing criteria. It's not, it is here, it says here in the bill. So all I'm saying is that as some of those criteria, the economy, heritage, safety, the minister may add others as well, aesthetics or whatever. You're already saying there, the minister might decide. You can then engage with the minister and say, well, aesthetics, you know, is a very difficult one to measure. Road safety is a difficult one to measure. Traffic flow is a difficult one. But then we must take that completely out. If you're saying we can't add criteria, then the minister also shouldn't be able to make regulations prescribing the criteria. So that is just my point, and I was hoping to be able to meet you. The economic value of roads, I don't think has to do with the advertising. We're not specifically talking about advertising. And may I say, Chair, I fully take the point made in this letter that we should not encroach on municipal functions. But I must say we were getting very close to that in clause 34, when we say a municipality must regulate the display of advertisements, and then we do start with a lot of prescriptions. So I think we're, with all due respect, within our ambit to be able to consider just giving some form of guidance to the minister, or can we call it minimum criteria for the minister when he wants to prescribe. Thank you.
I think what Member van der Westhuizen is saying is not, you don't want to tell municipalities what or what not to do. But if there is a road of joint significance, there are certain, you can't just, and particularly on the cultural aspect, we were in Oudtshoorn the other day, and I give you a practical example. And the night before, were you at that meeting with the Kwesa? No, you were not. With Kayla, you were there, yes. And they raised a concern of what's happening in the area, but the economic value. And I don't want us to go into a cultural debate, that's a separate thing. But it just springs to my mind is, what factors do you take into account, and who do you include, exclude when the minister is going to apply some criteria? So I don't want us to sit this unnecessarily, but I do get Member Andrikes' point. It's not encroaching on the municipality's area of safety, but the minister may say, listen, can you consider this? It doesn't mean he's going to agree with that, or not, obviously. Because if you do publish your regulations, there might be things you're going to include, exclude. I hope I make sense without. Sorry, Ashidiguch.
Through you, Chair, may I request, because I've got a similar sort of view, and so I want to be able to just chat with the team instead of us doing our homework here, seeing as if this is just proposed this morning. Like with the other one, if we could maybe have a few minutes just to chat about it internally and be able to come back to the committee. I'd like to ask my own questions. I've got a proposal, but I don't want to do it in the open committee, if you don't mind.
That is the last one that we had.
No, there's one.
Oh, sorry, one more.
Just one, but if I could just, if we finish this and then you can discuss.
Yes, that's exactly what we're going to do. So you had one more that you wanted to discuss?
You know that clause 37 has been troubling me for quite a while as well. And you've come up with a amendment. I still have my question regarding a person that's exiting his or her home. There's no fence. Exiting a shop right onto the pavement, which I presume would be the building restriction, the building line there. And what we are saying is no person may, without the prior written permission of the head of department, enter or leave a provincial road or a road of joint significance other than, in the case of non-motorized transport, via a lawfully erected roadway, gate, bridge style access or other means permitted by law, where access to or exit from the road is barred by a fence, trench or other obstacle. May I just confirm with you that we are on the same page. If I say this means that if I exit the shop in Franschhoek, I may cross the road to the other side of the road. Can I call it directly opposite that door, that entrance? Okay. I think I may have omitted to read that the last bit there where you say the road is barred by a fence, trench or other obstacle. So where there are no fences, you are permitted to cross. Anyway, okay. Then that one is not applicable. Thank you, Chair. Thank you.
So we take that out. So we're only dealing now with clause 32 for discussion with the officials, and then they can just get back to us for the clarity once you've done. So you wanted to ask, Amanda?
I don't think we made any comments on the new clauses proposed for farm signs and first-party advertising.
Which one are you talking
Member
about?
van der Westhuizen did go take us through them. That is on the ABLE page 2, B and C. Okay.
We're going to discuss it first, then you. So we'll
It's that one, and then also the B, the criteria. Yeah. Okay.
Yes. So we'll adjourn for 10 minutes. There's some tea and coffee for those who want tea and coffee, and we'll leave you here, and you can let us know how you feel. Thank you.
Shall we leave?
Yes, we'll leave here. Just close the meeting online, please. Thanks.
Then on 32.2 and through, actually 32.3, with the provisions there, our suggestion, if we may, Chair, is my understanding that following previous discussions that have been held, the team had actually brought in elements of what has been raised regarding the farm name and number into the draft regulations, and some updates that they had done. And I'd like to therefore suggest, if I may, that through you, Chair, that the team actually share that with the committee now, if you're comfortable, to then determine whether we've sufficiently covered the suggested thing for the bill in the regulations. One thing I can indicate is what is proposed as C, which includes the element about the warning signs, the direction to close gates, etc. That has not been covered in the regulations to date. And I do think it's a valid point, and we'd like to suggest that because it is a particular detail, that should also go into the regulations along with the other provisions, as we've got kind of farm size, the names, the sizes, the displays, etc. So that is covered in the regulations, and that farmers would be exempt from the necessary provisions that would be required. So we are suggesting, Chair, that as opposed to including that detail in the bill, that is put into the regulations along with the farm names and numbers elements that have previously been covered. So that we acknowledge is an omission that hadn't been considered that needs to be included. Thank you, Chair.
Okay. Amanda?
I don't have anything further. Thank you.
Thank you. Van der Westhuizen, that covers.
Can I just ask, Chair, my concern, as you know by now, is the fact that when the regulations are being drafted, they are being drafted from a singular viewpoint. Now, it is being addressed to a certain extent, and thank you very much for that proposed amendment. Can I perhaps just have the assurance, or should it then be written in, that those regulations should be shared for comment with the standing committee, whether it's in future infrastructure and what the name of the relevant standing committee might be, so that at least at that point members representing also other stakeholders, interest groups, etc., may be able to comment on those regulations. My concern is that the last word on it will be spoken, if I can call it, by the minister. That will just be signing it off. And as we've said in the past, I don't think one can always assume that the minister will be rational, etc., in this day and age. So what would be needed for any committee to be served with the draft regulations for comment before perhaps it gets published for public comment or some of the other steps that you would follow in drafting and finally adopting those regulations?
Thank you, Amanda. You'll send out.
I think we would be in agreement with such a provision being included in the A bill, and perhaps Mr. Marsdorp, Advocate Marsdorp, and myself could come up with a proposed provision that provides the draft regulations are provided to the committee for comment prior to being issued.
You're comfortable with that?
Chair, and then and thank you for those. I think that deals with all of what you've discussed, and thank you very much for addressing some of my concerns. Can I just say, in your letter that you've written to us, paragraph 4.1, you say...
Can I just get clarity? Are we going, if we've dealt with all the concerns that we dealt with this morning?
Correct, except that...
Is there a new matter you're raising?
Yeah, in this letter that Ms. Goods has written to us, they also propose an additional clause 71.3, which also deals with encroachments. Would you like to first...
Apologies, Chair. That's just quoting what a proposal by Member van der Westhuizen, and it's not the department's suggestion. It's just quoting that proposal and the department's response to the proposal.
So the proposal is turned down. Thank you.
Okay. Nothing else to
That's
add
it,
to
Chair. I
that?
don't think there was anything else that we needed to caucus on and feedback on. I think we concluded from our side. Thank you, Chair.
Okay. So that concludes all our concerns that we had. Van Wester, in your face looks like you wanted to raise a hand or something. I'm hoping inside I'm saying no. Okay, so that concludes our input into the bill. And is there any online questions from my members online? I know that you, colleagues, you were part of the technical briefings. Member Wimby was also been part of this for a long process. So I know he's also probably had his fair share of this bill.
Yeah, no, Chairperson, it's true. And I'm glad we seem to have come to some conclusion on it. And I also would like to thank you also the way you've been also very patient and accommodative, and making sure that all those who are having issues of concern are actually being addressed. No, I don't have any further input, Chairperson.
Thank you very much. And thanks to the department. I think from here onwards, we're going to hand over to you just to finalize with Romeo. And then it needs to be certified. Then it comes back to us next week, which will be a 30-minute exercise. We don't need you here next week now. Do we need the department here next week?
Yes, Chair. They need to be, but Chair, if it's okay with you, if we can do it an online meeting.
Yeah, but it wouldn't be a long meeting because we're just going to go adopt the A-bill.
And then do the formal stage.
Yeah. So that it doesn't, in fact, HOD, if you've got something else, your colleague is comfortable to handle it on his own and he can just come because we're just going to go clause by clause and adopt the A-bill. So, and Amanda will cover your back. So in case I sneak in a comma or something there, she will definitely call us out. So thank you, Amanda, and thank you, HOD and your team. I know this has been a long process. We do appreciate, and your colleague online as well, Stefan. I think it's Stefan? Steve, thank you for coming through. And we do appreciate and thank you for your patience. I'm sure Amanda, if Amanda has grey hair, we know it's Andricus that contributed to that. But yeah, we appreciate it. Thank you. You guys are now excused and we'll take our administration forward. In fact, colleagues, we're not going to do anything until next week. So we might as well adjourn the meeting. Thank you, Member of the West Station, and drive safe. Thank you, online colleagues, Member Seleko, Member Wimby, and everybody online. We appreciate your patience. This meeting is adjourned, and you'll get a notice for next week meeting. Thank you.
Thank you, Chairperson.
Thank you, Chair.
On for all your hard work and Fundo when and Johannes online as well. Of course. Thank you, Ms. Maasdorp.